Okay. I will call the February 9th meeting of the Manitou Springs Planning Commission to order. First item of business is a roll call. Commissioner Armstrong. Commissioner Reagan.
Present.
Commissioner Casey.
Present.
Commissioner Wilson.
Present.
Commissioner Carey. Oh, sorry. Commissioner Storm, excuse me. I was on a roll. I got it almost right. Okay. Next item of business is approval of the minutes of the January meeting. And I have one minor correction to start. Now, on page 7, there's a reference to the motion that I made for the second item. And it says I called out, I think it's item B, C, and F, or something like that, of 1805. It should be 1805-080. It's right at the end of the thing, right before we vote.
So where is this located in the minutes? You said page 7?
Well, it was page 7 of the packet. Sorry, I didn't have the separate minutes. It should be right at the end probably, because I think, or at the end of that second item.
Page 6 where it says chapter 18.05 should read 18.
05080.
All right. And did anybody capture or know who seconded the nomination for Alan Dulwich? It wasn't captured, and the recording is less than desirable.
Dylan, I think it was David Armstrong.
No. Okay. So any other corrections to the minutes? Okay. There's a motion to approve.
Motion to approve with the amendation offered by the chair.
A second? All in favor?
Aye.
Okay, that's, next item, I believe, since I don't have the agenda in front of me, is the, Austin, now you have the floor.
Thank you, Chair. See, you guys hear me all right? Okay. Okay, so we can keep this pretty informal tonight. I'm going to be going through what I consider my hot button legal issues for a planning commission. As I go through each topic, feel free to interrupt me and ask questions. And at the end, we'll have a period of anything I didn't cover if you still have questions. Now, I've given you guys a memo that goes into Jeff's hot button issues. They might be slightly different than mine. I'll be covering all of those issues broadly today. I'll also be covering some different issues. So the memorandum is just for your guys' own edifice if you want to read through it at your own time. And if you have any questions on that, feel free to email me and Jeff. So we'll get started. This is all we'll be covering today. I know it's a lot, but we're going to go at a pretty high level, and I'll hopefully not bore you too much. So I always like to start with the purpose of the Planning Commission. This is from the city website, but it has its derivative in the city charter. I think it's a good filter for all of the decisions that the Planning Commission makes to ensure that they're in line with that purpose. Okay, so let's talk about the Planning Commission's scope of authority. I would put this into 3 different buckets: advisory, legislative, and quasi-judicial. And advisory is really a bit of a misnomer because advisory decisions, like recommendations, are or quasi-judicial actions. Is it a bit of a weird feedback? I wasn't sure if it was my ears, and I thought I should really get that checked. Any better? Maybe? Great. Thanks, Dylan. Okay, so the authority derives from that section listed in the municipal code. Primarily, your authority listed in the code is to create a comprehensive plan, and that aligns with state statute. However, you have additional authority granted to you by City Council over land use recommendations and decisions. Those can be found in Title 18. So some general considerations for a planning commission. The commission should act as a body and not individuals. No single member has authority to act on behalf of city on their own. No authority to spend city funds unless expressly provided by the city council. There's no authority to direct or supervise city staff. City staff works with boards but is not subject to their control, so you should reach out to the supervisor to whom you want to speak with, and then they can direct staff accordingly. Any legal advice provided by myself or Jeff or any other city attorney helping you guys out is confidential and should not be disclosed to third parties. And then no individual member has the authority to bind the city legally, meaning you can't enter into contracts as a city representative. You can only enter into contracts as a body. You're not a separate legal entity apart from the city, you act as a city. So I am a city attorney to Manitou, which means I represent the full city. You guys in particular is what I spend my time on, but there's sometimes contradictions between different bodies and staff members. I have to keep the city's interest in mind in those matters. Cool. Okay, so this is kind of the meat of it, or we're getting into the meat of it. So when we're thinking about the three different buckets to which your actions as planning commissions fall into, I think that these three buckets capture them. I'm going to spend a bit of time on the quasi-judicial bucket. It's the most important legally. So a quasi-judicial decision is a discrete act related to a single item. So for example, if you approve a minor development plan, you just made a quasi-judicial decision. Again, as I stated early, advisory decisions, including recommendations on an agenda item, are considered quasi-judicial. So due process is triggered with quasi-judicial decisions. I consider due process as requiring three main things: notice, a hearing, and neutral decision maker. And you'll see the lens of quasi-judicial actions filtered into those three buckets. So the most important thing is that you apply the criteria in the code to the evidence presented at the public hearing. You must be fair and impartial, no ex parte communication, no bias. So what all of that means is that for due process to be met under the US Constitution, we have to provide a fair opportunity for someone to get a hearing, to be heard on the record, for you not to prejudge or make a decision before you are opening the record at that hearing, and that there's no implicit bias in the decisions or the adjudication of that matter. Quasi-judicial decisions are really important from a legal perspective because they're subject to judicial review, and courts don't look at them very friendly. Meaning, if it's in the court, if an applicant has exhausted all of their administrative remedies, they've either appealed to you or the city council and they were denied or just are not happy with the way that the application turned out, they have a right to appeal it in district court. If they appeal it in district court, the first thing they're going to say is that my due process rights were violated. This wasn't a fair go at a hearing. And they're going to list all the reasons why they don't think it was fair. Another thing that they'll probably mention is that the decision was a violation of, in Colorado, what we call 106 review. That means you acted outside the criteria in the code. You did not use the code to make a decision. So we want to be really careful to not trigger any due process violation or any 106 violation. That's what would be appealed. That was a lot of jargon. Any questions on what I just stated?
let me examine this a little bit more. So Dylan would send us information in advance about a proposal, and that could be quite detailed. And I would go out to the site, and it might be a controversial thing like approval for a short-term rental or approval of whether the project is going to go ahead or not. And I would look at it and I'd say, oh my God, that hotel is horrible. It's bad design. It's way too close to the street. I don't like it. It's inevitable that I'm going to prejudge some of those things. Now, that doesn't mean that I cannot be impartial and wait for my, quote, final judgment at the actual meeting where the applicant has a chance to present information and we discuss it and so forth. But that seems to me to be fraught.
That is a great question, and a great way of wording the difficult balance you have as planning commissioners. Of course, you have insider information to probably every single application that comes before you. That's not something you need to completely disregard as commissioners, but what you can't do is make the decision before you've actually seen the public record. You're free to go by a site to which an application is associated with and analyze the site, and then bring that information to the hearing, look at the criteria, look at all of the information in the public record, and it can influence your decision, and that it can be applied to the criteria before you. If you say, I've seen the design, it doesn't meet the standards in the code, well, they just missed a criteria. And you can use that as your basis to make your decision. What you don't want to do is say, I live in an area next door to this, all of the neighbors, they hate it, we've already talked about it, we're not going to really listen to anything you have to say tonight, I've already made up my mind. That would be prejudgment, and that would be grounds for a due process violation. Does that distinction make sense? It's a really delicate balance of being an insider to this information, but not prejudging, not making the decision before the record is before you at a public hearing.
I'm smart enough not to say, oh, I've prejudged it and figured it out before the meeting.
Right.
I'm just theorizing here. I'm not going to say that I came here tonight intending to vote against this proposal.
I think the concern for me would still be if the information to which you're making the decision based off of can't relate back to, one, the evidence and the criteria to which a decision is made. You can't just have a feeling of, I don't like it. You have to look at the criteria and say, I don't like it because it doesn't meet this criteria based on the evidence presented before us. Does that make sense?
That makes sense. And if Tip figures out that, I've got an emotional reaction to this, then he can say, David, what specifically is it that you object to here based on the code and on the various criteria?
Right.
Okay.
It seems to me that part of it is just getting in the mental space, and I've had this happen a lot of times. I can read the material ahead of time and think, oh, this looks as if it might be a problem vis-a-vis the code, but I might think, oh, there seems to be a lot of evidence in that regard, but I've been surprised that when I come in and I hear other points of view and evidence, that I end up making a decision that's different than I thought at the onset. And so I think that if you go into the meeting recognizing that you have to get all of the information out in the public eye, and then you weigh it, that you're open to whatever outcome is right. Do you know what I mean?
You've made that a specific comment more than once. I'm afraid, if I'm being honest, you're better at that than I am, but at least that's a positive example of what I need to do,
Yeah, I'll just echo what Tip said. I can't think of how many different meetings. I've read the staff reports and looked at the site, and I come in and I think I know exactly what the answer is and how I'm going to vote, and I hear the testimony, and I hear maybe the applicant or maybe someone in the audience sort of turns on a light bulb and makes me see a complete different perspective, and I always end up deliberating at the last minute and making my determination. But it's easy to go in and have somewhat of a sense of what you think, but that's what's great about the public hearing. And that's why I always, I'm happy when we have a lot of people come and they express their feelings, either pro or con. And that's what makes the process work. And we all get better as we hear it. I mean, we had a height variance a couple months ago that I scratched my head and I went around and around and I couldn't understand the rationale. But after talking through it and hearing everybody on the panel, all of a sudden I could see it and it made sense.
Those are great examples. Anything else on quasi-judicial? Yeah, Dylan.
Yeah, do you have any advice or guidance on how the commission should weigh public comment versus the code requirements?
Yeah, that's a great point. I think public comment is really important to elicit potential concerns that you might not have thought about, but those comments and those concerns need to be related back to the criteria for you to take them into consideration. If I don't like it, and it's not related to the criteria, then you can't consider it as a part of your decision. And so you've probably heard a lot of public testimony that you couldn't consider, even though it might be heartfelt or emotional. You have to put that information aside when you're making your decision. Does that answer the question, Dylan?
Yes, thank you.
Of course.
Austin, what is your interpretation of the definition of quasi-judicial?
Yeah, quasi-judicial is a legal term of art. It means that you are the adjudicator, meaning you're acting as judge in a decision. Not helping. So if you're acting in the eyes of the law as a Article 3 judge, meaning that's why your due process rights come into play, because the court will evaluate any concerns as if you were an actual judge rendering a decision on the matter. When I say Article 3, I mean Article 3 of the Constitution, which is our judiciary branch article. And so they look at it through the exact same lens. They call it quasi-judicial because it's not actually a part of the judicial branch. It's quasi, but we're going to treat it as if you are. We're going to give you the same rules as a judge. Does that make sense? Or kind of? I'm not sure if I don't know if anyone else has anything to add to make that more clear. No? Okay. Okay, so that's a really important one. The second big task that you guys do is legislative concerns. So legislation, when you're passing legislation, think the comprehensive plan or zoning regulation amendments or ordinances, what have you. Those are generally applicable policies, meaning they are not quasi-judicial. They do not have any of the same legal requirements. Me and Jeff will be sweating a whole lot less when you guys make these decisions because you don't have that Article 3 legal standard that I just described. You're not acting as judges, as adjudicators in the matter. You're acting as policymakers. So when you're acting as policymakers, the legal threshold is much lower. That doesn't mean we should just willy-nilly do policy decisions, but there's less legal ramifications for those actions because they apply broadly. They're not specific, they're not judicial in nature. So all of these, I put this at the bottom, all of these, no fraud. I just didn't put it to quasi-judicial, but that's the baseline. So you get an idea of the different legal standards between how high it is in quasi-judicial and how low it is relatively for legislative action. And then I put a third bucket, which is basically everything else. When you're just in your everyday today lives, you're still commissioners, you're still representing the city. So I just think it's good to keep that in mind. Any questions on these three buckets before I move on? Okay, let's talk about open records. So this is governed by the Colorado Open Records Act. It's commonly referred to as CORA. Under CORA, public records must be open to public inspection. Public records are very, very broad under CORA. All writings made, maintained, or kept by a public body is a public record under Cora, and they're subject to public review. The exception to that is what they call work product. This isn't, if you're familiar with the legal doctrine, work product doctrine, it's completely different. Under Cora, what work product means is a communication for the purpose of assisting elected officials in reaching a decision within the scope of their authority. It's a lot of jargon. What it means is if you're looking at a criteria, you don't know what it actually means, and you email Dylan. Dylan, can you help me interpret this criteria? How have we used it in the past? Do we have an interpretation for it? And Dylan sends you back an email. Jeff and I will likely be able to get an exception for that and not have it released as a part of a Cora request. Does that make sense? Okay, cool. Well, no one's sleeping, so that's a good sign. So that's all I really wanted to cover under Cora, but I think the main thing I want to keep you guys in mind is that any communication you guys make is probably subject to Cora, meaning it can be part of a public disclosure, it can be part of journalist interrogatories, what have you. And we see it more and more these days. So just be aware when you're sending emails, when you're doing anything, that it could be subject to the public domain.
What do you mean you see it more and more?
Cora requests are becoming increasingly more frequent, so much so that we are hiring positions and many of the clients we represent just for Cora requests. They have become a lot more prevalent with a lot of the recent social movements and journalism in regard to them, if that makes sense. Okay, any questions on the Open Records Act on Cora? Awesome. So open meetings law. The open meetings law is governed by the Colorado Open Meetings Law. There's no fun little shorthand for this one. Essentially, this is a notice statute. Essentially, it just requires that any meeting be given 24-hour notice. You have a 24-hour notice requirement and it must be open to the public. That's the broad requirement, essentially just notice. Something that a lot of planning commissions I don't think are fully aware of, that if you add a new agenda item with less than 24 hours, you probably just violated the Colorado Open Meetings Law. There's a very, very small exception for emergencies. Those are typically only emergency ordinances. If you ever have the case where you have to add something to the agenda with less than 24 hours, email me and Jeff, and we'll see if we can get it under an exception. If we can't, then we need to push it out. Likewise, emails of elected officials can constitute a meeting under the Colorado Open Meetings Law. So if more than 3 people are in an email chain, 3 commissioners are in an email chain, it technically needs to be noticed and open to the public. And it's also subject to Cora. So keep that in mind when you're replying all or what have you. It could technically trigger both the Open Meetings Law and Cora. Any questions on the Open Meetings Law?
Just clarify, you said more than 3, you meant more than 2.
Sorry, more than 2. Yes, thank you. Any questions? Any other questions? Okay. We're breezing through this, guys. Thank you so much for your attention, patience. Yeah, please.
With the open meetings, I just want to mention, even if you're standing here and the 3 of you are talking about an item, that is considered a meeting. And so I do know of one city clerk that if they see 3 people standing and talking, they separate them because the perception is a meeting is taking. And if you've talked at all about any of the business, that is a meeting. So you got to be real careful regarding that too.
It's an excellent point.
But from that, if I said to 3 people here, why don't you come over to my house for a glass of wine, and we don't talk about the commission at all, that's in the scope of the law, correct?
Yeah, you're good to go, as long as you're not talking about any agenda items.
Yeah, okay.
And I'll get to this later. I'll get to it later, but yeah, I'll circle back to that point, because I know it comes up a lot. Okay. Okay, so this is a part of the open meetings law, executive sessions. It's an exception from the general rule that meetings must be open to the public. You must state the authority for the executive session. I've listed some examples up there. This is another one of those cases that is kind of tricky legally. And so whenever you are pretty aware that you want to go into executive session for an agenda item, be super helpful if you guys let me and Jeff know beforehand, and we can prep you guys beforehand to ensure that we're checking all the right boxes. I typically give my chairs a script to read to go into executive session and when we're in executive session, just to make sure we're checking all of those legal statutory boxes. It's one of those things that I think generally the public doesn't love, and so we've got to be really careful about protecting ourselves in that way.
Do we encounter that in planning commission?
In the 28 years that I've been on the commission, there was one time where it should have happened,
Oh,
and that was about 15 years ago, and it triggered a little change in our process. That's why we do that opening and try to describe the process. That came out of that faux pas that happened.
That's good to know. I have some clients that go into executive session almost every time. It's because they don't want to ask their legal questions in front of the public, which they have a right to. So, okay. Excellent. Conflicts of interest. This is also an incredibly complicated area of Colorado law. I've listed all of the statutory and acts that conflicts of interest in Colorado trigger, and then we also have some local provisions on it in Manitou. It's extremely complicated, but big boilerplate point is that you cannot perform an act affecting your economic interest or a family member's economic interest. So that's, big broad point. If we're not doing that, then we should be good for conflicts of interest. Steps to avoid a violation: disclose the interest, and then if necessary, you recuse yourself and leave the room. Manitou has particular provisions on whether it actually is a conflict of interest, so always disclose first, and then we'll open up the Manitou Springs ordinance, and then we'll have a discussion on whether we think it actually is a conflict. The commission will vote. If they vote that it is a conflict, that person needs to recuse themselves and leave the room, and then obviously not influence the decision. One thing I would note is that also a local ordinance in Manitou is that you may only recuse and abstain for a valid reason, meaning you can't say, I don't want to vote today, I'm going to recuse myself. That actually is against the law in Manitou. So we'll talk through that if that ever comes up, but just to let you know, you must vote if you're here. Any questions on conflicts of interest? Excellent. Okay, this is my last subject actually of the night, so we breezed through that. Governmental immunity and personal liability. So I'm kind of coming all the way back to the beginning of the scope of authority. The broad point here is if you're acting within your scope of authority and you're not acting willfully and wantonly, then you're going to be covered under governmental immunity and personal liability. Does that make sense? Great. So those are actually the only points I had to bring up to you guys tonight. As I said, the memo kind of goes into a little bit more detail on some of these issues, but it also doesn't cover some of the issues I covered tonight. So this is a good opportunity to ask any questions I didn't bring up or any clarifying questions. Anything that you guys want some legal clarification on, this would be a good time. But if not, I so appreciate your guys' attention. I know it's not always easy listening to these things.
I was thinking that we have had one or two abstentions, so maybe I misunderstood. If there's a proposal to approve or deny, and I really don't have an intelligent stance either way, I still have to vote? Is that what you said, or is that not?
That's correct.
Oh,
And I can give you the code section. I might give it to you after the meeting, but I have it somewhere in my notes.
well, I trust you.
Yeah, definitely.
What if the conflict of interest, you said that you had to acknowledge the reason? Do you have to acknowledge the reason?
Yeah, you should, because the planning commission should get an opportunity to decide if it meets the standard for conflict of interest and then vote on it.
Oh.
If it's a privileged matter, then of course you wouldn't have to ever share that, as in it's protected under some legal privilege. But generally, it's hard for me to imagine a case where that would happen. So yeah, generally you really should be disclosing the actual interest.
Can we get a copy of that presentation?
Yeah, for sure. I've got one on me and I can email Dylan.
Yeah, just a clarification on procedure. We've had, I'd say over the last couple of years, maybe 2 or 3 times where people have recused themselves because of a conflict. And typically it's been like a realtor type thing where they're involved, and we haven't gone through a formal process of voting to vet that. Is that okay, or do we really need to change our procedure there?
I think moving forward, my preference would be that we disclose the interest particularly, and then the planning commission votes on it. I can talk to Jeff if that's the way he's been advising you in the past and ask why he's been doing so. I'm curious why he would do so.
Yeah, we've never gotten that guidance before, and it may be we just didn't read the right regulation, but that's, in the past, it's pretty much been.
Right. I mean, I guess I don't have too much heartburn with it if you're like very positive that it's a conflict of interest. It's this delicate balancing in the local ordinance of not being able to recuse yourself if you have not met the conflict of interest threshold. And so that's why I would advise that you should disclose and actually vote on the matter, and then it becomes part of the public record. But let me circle back with Jeff, because maybe he has his reasons.
Okay.
Austin, what if it's not like a conflict of interest, but you feel that you can't be impartial? Could you recuse yourself or ask to be recused on those grounds?
Technically, no. I guess if you feel you haven't been or that you can't be impartial, I would wonder if you could fall under some conflict of interest provision, but if it's not financially motivated impartiality, then I think you have to do your very best to be impartial. And it's probably more of a fact inquiry. I think that's probably a good area where if that did come up and you said, hey, I have some concerns about voting about this, it'd be a good reason to probably trigger an executive session to get legal advice off the record. And then we can proceed from there. That'd be my advice. Good question.
So where does a planning commission in a small town like Manitou, where everybody is civil and cooperative and mature, what is the hot water that you know that your clients get into?
So much. Oh, yeah. Oh, yeah. Oh, we've had so many things blow up even in the past couple of months with our planning commissions in particular. So these orientations are really important to allow us to try to get ahead of things. It's often when an applicant doesn't get the votes the way they wanted, they feel that they can use something that has been said to either say that the process was unfair and there was a due process violation, or it was arbitrary and capricious and the planning commission acted outside of their scope. And when it becomes a legal battle, it just becomes so much more work and kind of a waste of everyone's time, honestly. So as best we can to avoid that, that would be great. But I'm happy to hear that isn't an issue in Manitou. And I would assume that with you guys, we won't have any issues going forward.
It has been an issue in the past, but not in the very recent past. But there have been examples of the mayor or several city councilors saying to some people in a case, we are not authorized to talk to you. And with the other people on the other side, they were doing email chains and advancing the case. So that has happened here. But fortunately, I don't think we're in that situation now.
Right. Well, it's good to hear that we're not in that situation now. That's a good point to bring up on ex parte contacts. I think people generally have some confusion of what that means. My advice to you is whenever you get an agenda item comes up before the agenda item was decided on, tell them, upon advice of my city attorney, I can't speak about this. You're welcome to come to the public hearing and we can speak about it further on record. That'd be my advice. Sorry, Denise, did I cut you off?
I got something off topic if you want to talk about this.
Just two things is, I do have Austin coming now to all planning commission meetings. So he will be in attendance for your meeting. So if you have legal questions, or he'll be monitoring if he feels that something is not going the right way, he'll definitely interrupt. So I do have him coming from this point forward to all planning commission meetings. The second thing I wanted to point out, if you ever have a legal question, please do not go to the attorney directly. It costs us money every time you do that, right? And there's research. So I ask that you bring it to me, and then we talk about it and decide whether it should go to the attorney or not, and then we manage that accordingly. So that's the other item I wanted to bring up.
Sorry, that's a good point.
Just a different topic. And no need to go into detail, just I'm planting the seed, but I think it would be nice if we could do the 2-minute open any conversation prior to the meeting like city council does.
Yeah, that's totally a matter of your guys' discretion. There's no code requirement that you have to have general public comment period. I typically advise that you do, because it allows people to get their kind of 2 cents out there, even on just on non-agenda items. And so it's, again, more of that contact with the public that I try to encourage when it's on the record. It kind of avoids the situation of people just coming up to you and yelling or what have you. But totally a matter of discretion. If that's something you want to add, I'm sure that you can talk to Dylan and he can add that as a part of the agenda item.
Well, we can talk about it, I guess, but generally speaking, we can ask questions, but we can't make decisions, right?
You can ask questions, but you can't make decisions.
To the person that's saying the 2 minutes?
If it's a general public item, not agenda item, you just say, thank you for your comment, and you don't ask any questions, you don't have any sort of interaction.
Okay.
It's just a moment or a time for them to get their 2 cents in. And I do typically limit that time, because sometimes you can have really long public comments, but I would just say 2 minutes, and then after they're done, I just have the chair say, thank you for your comment.
Okay, the concern I have with that is if there's a particularly heated item coming up, and it's going to be on the agenda for the next month, I could anticipate someone getting up and going off on that.
Yeah.
And that gets sticky, then the applicant for that item feels like they've been maligned because they didn't participate.
And we shouldn't allow that. If you ever have that happen during a general comment period and I'm here, then I will cut it off.
Okay.
If I'm not here for any reason, then I would request that the chair cut it off and say that we're going to have a public hearing on this matter. You can tell them the date and to come back for that time.
Okay, would it be reasonable for the chair just to preface by saying non-agenda, also please, anything that's on an upcoming agenda?
Right, like a complete non-agenda item, just general. I don't like the swings at the park or something like that.
What if it's an item that hasn't yet been an application, but it's being talked about? So it could come in 6 months, it could come in 3 months, but then they've heard a perspective without having the application submitted yet.
That's a great question. I do typically allow those. If you don't have an application before the city, then I can't point to one ever being created. There's no certainty that it will ever be created. You should still keep that in mind as far as prejudgment, and you shouldn't use it to determine anything about that agenda item if it does later come up, because it's not a part of the public record for that agenda item. That's a great question. I think maybe that goes into the reason that you guys chose not to include that period. Again, it's totally discretionary, totally up to you.
Just to make sure I'm following this and following up on Denise, if for example, maybe there's a lot of discussion in the community about VRBOs, and there's always this kind of thing hanging over, like, are we going to go back and review our criteria, whether that would be in a year or 6 months or 5 years, we don't know. Is that the general kind of commentary that's okay?
Yeah, I would say so. I think I have less heartburn about that scenario for two reasons. One, because it's speculative, it's not actually a pending matter. And two, because it's legislative. That's kind of the feedback that you want to hear as your role as a legislative body, knowing, hey, people seem to really care about this, maybe we should take it up. That's my 2 cents, but Denise, if I am stepping on all your toes, please shut me up.
No, I think it's up to all of you. It's just, as Alan and others has brought up, it can cause, I think, a concern. That's it. Because the applicant may say, you guys heard this 4 months ago before I submitted, and you already have a mindset about this.
Right.
Real quick, we don't need to go into painful detail on this, but I think if city council can do it, we can do it. That's my take. But maybe also when you, if you could add this to your presentation maybe and just put your 2 cents on
Sure.
Do's and don'ts.
Sure, yeah.
Okay, thanks.
I'd like to give Commissioner Storm an opportunity to ask questions if she has any. Commissioner
I
Storm?
don't have any. Thank you, Dylan.
Okay, you bet.
It's interesting. Thank you. I would like to get a copy of the presentation.
Okay.
Thank you.
Well,
I think this is relevant. If not, just say so. But I'd be interested to hear you talk about the relationship of Planning Commission to council. Many years ago, I was disturbed or concerned because they seem to be operating from two different sets of criteria. And I think it's harmful to the city if city council routinely overrules planning commission because we're applying the same criteria to decisions. Now, they have a different responsibility than we do, but, well, can you talk about that?
I'm not sure I would, I don't know if I would really know what to say, honestly. That's definitely a common issue. I see it a lot where planning commission has different perspective on the criteria and so apply it differently. And then the city council comes back around and reverses what they've done. I see that a lot and it causes a lot of tension. I think from my perspective, as long as both are reasonable applications of the criteria to the evidence before them, I don't step in those matters. I know this isn't helpful at all, but.
No, yeah. What you're saying is there can be a completely legitimate difference of opinion. Now, that's
Right.
where I'd like to be sitting down informally with city council, a member or two at the keg and, hashing it out, but I don't think we're supposed to do that.
We can add that to the meeting as well.
Well, maybe on that point, I've been wondering if something was already adjudicated a year ago or 2 years ago, could we talk with each other about that or talk to a city councilor about that?
Yeah, when matters are already decided in finality, as in they won't come back up as you saw them, then yeah, it's free to discuss those matters. There's no due process concern in that case because you've already adjudicated the matter.
So in that way, David Armstrong could talk to somebody to try to understand what had led to a decision and have a better sense of the different factors, and then that would go into his toolkit about how to think in a quasi-judicial way moving forward.
Yeah, I think so. I mean, you see this quite a lot with high-profile trials, that after the trial is done, jurors will give big exposés. It's completely legal to do because there's already finality in the decision. I think I still have a little heartburn over it. It's a matter of practice, but I can see the benefit to it.
Would an applicant have any legal standing if he said, well, the planning department approved my project or recommended approval of my project. I coordinated them over a period of 18 months, did everything that they suggested, and then the planning commission approved my project. And then I invested a lot of money, time, energy, et cetera, with that project. And this is this happens. And then council, they rejected it, and it looked to me like, well, that's where you have to be able to substantiate your decision, right?
Mm-hmm.
It can't be just an emotional,
Right,
oh, the community is, in general, it's
right.
opposed to short-term rentals, so boom, we'll knock it down or something.
Yeah, they need to base all of their decisions, just like you guys, on the criteria before them and the record before them. So it shouldn't be based on emotion or politics or anything
Well,
else.
we're normally, or very often, dealing with some exception to the rules of variance. And Manitou is, by nature of its physical layout and its history and what have you, there are all kinds of exceptions. So, yeah, that disturbs me that when an applicant acts in good faith, comes before the council, before planning commission and has done everything right, so to speak, and then they just get shut down
I think, though, that for those items that are a two-step process, a recommendation from us and approval by council, that just is part of the due process. And you know, if actually, I think there was one case where we recommended something unanimously and we were overturned by council. But in general, when I've seen it happen, it's been more, you know, like a 4-3, 3-4 type of situation, which is, you know, you can understand where there's, you know, interpretation, you know, that judgment thing that could go either way. And that's why it's two-step. You know, things like variances, we are the final authority unless the applicant appeals. But, you know, for the most part, I think we've been following the process.
And it works.
Yeah. Mike?
One last one. I was reading your memo, and it says that an applicant can appeal an unfavorable decision. Can't the general public appeal a favorable decision? The reason why I'm asking this is I thought anything could be appealed by anybody.
Are you talking about to a court or appealed within the city to the city council?
To the city council.
Okay, so
Our decision.
right. So if you guys are the final decision maker and the city council has appeal authority on that decision, on that application, then the appeal should be coming from the applicant, not a third party. However, I haven't justified that in the Manitou Code. It sounds like you guys may have a very broad standing provision, and I would need to look into that. If anyone is allowed to appeal a decision, then sure, anyone can appeal it. If that's what the code says, I'm saying I need to look into it. I typically wouldn't have, if I was writing the code, that broad of a standing provision, but I have absolutely seen them, definitely in older codes too. So I would need to look into the criteria for standing. If you're appealing to a district court, as in the administrative remedies have been exhausted, there's no more appeal available at the local level, and you want to go to district court, you would not have standing to appeal if you're just some third party, non-applicant. But it could be different on the city level. I need to get back to you on the standing requirements for the city. Good question.
That strikes me as curious, and so I just want to make sure you say it again. Let's say a neighborhood is opposed to an application to do a massive development. And let's say that I'm just going to make the end case scenario. Let's say that the Planning Commission recommends against it 7-0 and bases its findings in the things that we're supposed to do, that it would be detrimental to the property values of all those people in the neighborhood, all those kinds of findings. Then it goes to the city council, and the city council votes 4-3 to override that recommendation and to approve it. Are you saying that a neighborhood that feels that it's going to have an adverse impact on their property values and thought that they did not get due process from a city council would not be able to go to court about that? That strikes me as strange.
No, you're absolutely right. So I definitely misstated the applicable rule of standing. To have standing under district court rules in Colorado, you must have a particularized injury in fact, meaning it must be a real injury to you as a person. You can't appeal as a neighbor just saying, I don't like it, I don't like the way it looks. You can appeal as a neighbor saying, I don't like it because I don't believe due process was carried out fairly to me. I had no opportunity to be heard. And I believe that the criteria wasn't met, and this is hurting my property values. There's your injury in fact. So, very good point. Thank you for allowing me to clarify. It's very difficult, but in the scenario just mentioned, that probably would be enough for standing to appeal a local decision. Did I misstate some other things?
No, I just wanted to say the appeals process is in 18.44.040, and it's very clear of what happens with the appeals. So administrative appeals, so something that happens from an administrative decision can be appealed to the Planning Commission, and Planning Commission decisions can go to City Council, but there's very clear guidelines of what has to happen and how much time. So it's under Section 18.44.040.
Does it clarify who can make the appeal?
That's great. Thank you, Janice. And I will also familiarize myself with that. But it is kind of, I guess, a good broader point to state that the standing requirements locally are going to be different, as in if you're appealing within the city, they're going to be different than if you're appealing to a district court, which will require constitutional standing, which is the standard I had described earlier. But that's a great example. Thank you for bringing that up.
Yeah, we had one a couple of years ago where a neighborhood wasn't happy with the decision on a short-term rental. And it was, we are the final authority on that, and they were going to appeal that to council. So there is that, that legacy or that history we've had. Karen.
And then also we have the protest petition revision in our rezoning ordinance, rezoning statute, which allows, I think it's like 20% of property owners within a certain distance to file a petition, which I guess is one way of doing that too.
And that's for rezoning, not annexation?
I don't know about annexation.
Okay.
But definitely rezoning.
Interesting. Thank you. Anything else? I hope this was at least surface level helpful.
Good.
Oh, thank you. I appreciate it. Thank you guys for your attention. I really do appreciate it. If you have any questions, you ask Denise, and then Denise can send them on to Jeff and I. Thank you, guys. Yeah, wine nights, beer nights, just email me.
Okay, if we're done with that, we can move on. The only other item we have is a notice of council action. Does anybody? I don't know. I guess the one council action we know is the rezoning request was affirmed by city council by a vote of 6-1. And I guess people, they read the bulletin, they saw that.
The other thing was that they approved our recommendation for language about the commercial zone.
Right, good point. Yeah. Okay. Then with that, I guess we are adjourned.
Thanks again for helping me out, Dylan.
You bet, Carrie. Have a good rest of your night.
Thank you.
Bye-bye.